Sorry, I forgot to
knows
start.
this stuff upside down and backward compared to us. And to me, I'll say anyway, I think that having this be an appellate review and where we just look for any error of law that we're able to notice and whether or not the documents support the decision is the most legitimate kind of opinion that we could render, especially now in light of the fact that, well, I guess that wouldn't be what would go to Superior Court, would it? The Board of Appeals reviewing and an appellate review, can the applicant still appeal to Superior Court after that?
Yes, they do. Yeah,
And then
so they
the
still get the
Superior
local
Court-
process.
Does Superior Court go all the way back to the planning board record then?
That's right.
I think that's the most honest appeal process.
You have an
More
example
honest.
of that. You have an example of that. I'm sorry to interrupt.
What were you going to say?
Oh, I was just going to say, you have an example of when that recently happened, and I'm just double checking under your shoreland zoning appeals. And so you may remember there was a shoreland zoning approval from the planning board. It went to the zoning board. You had an extensive hearing. You had findings of fact that was further appealed. I believe that's still in court actually, but the review was actually of the planning board's decision in that case.
And just
Because it was a determination that that was actually an appellate review, I believe, under, I wasn't the board's attorney at that time. I was helping the planning board, but that I believe they reviewed it in an appellate review.
Yeah, so that was the case down on Sandy Cove. Right.
So my note on here was I agree that putting this project evaluation in the hands of the board, of the planning board, with us having appellate review, unless it's stipulated specifically otherwise somewhere, seems to me to be logical.
Yeah, so I've been able to look at some of these while we've been talking, and what you have right now are essentially a hodgepodge of different appeals review standards based on the ordinance. So under your Board of Appeals ordinance, the default is de novo, and so if a ordinance is silent, then it's de novo. And so far, I've been able to find that that's the commercial development ordinance is silent, and the floodplain ordinance is silent. The shoreland zoning, on the other hand, is explicitly appellate. It says explicitly that code officer decisions are de novo and planning board decisions are appellate. And then the multifamily dwelling is directly to Superior Court, and subdivision is directly to Superior Court.
So Phil, if those ordinances are silent, but if the appeals board ordinance says that it would be an appellate review of planning board decisions, would that take precedence in that case?
Yeah, that's right. That's the way I'm reading it. So because that sets a floor, that sets the default, your Board of Appeals ordinance sets the default of de novo. That's what you would apply unless an ordinance says otherwise. So for example, a shoreline zoning ordinance says otherwise, it says appellate. And the multifamily dwelling and subdivision says otherwise, it says directly Superior Court.
So does this paragraph change the default?
It does
Yes.
not yet.
I mean, if we
It does not
switched-
yet, but if you switched it, you could make it appellate. We could use language that's similar to what's in the shoreline zoning to make it consistent, and just said, you could flip, what you could do is you could flip the default, is you could say it was appellate unless an ordinance says otherwise. And at this point, I'm not sure I can find one that says otherwise, but you could leave it like that in the event that in the future you wanted to have certain types of decisions be de novo.
So Phil, just in anticipation that a change might be made, I was wondering, would you suggest that maybe we have paragraph A that speaks to the de novo reviews of code enforcement decision, and paragraph B speak to the appellate reviews of planning board decisions?
Right. Or A1 and A2. You could just have 2 paragraphs under A. So you don't have to renumber everything.
Oh, okay.
If you want to take a look at how it's done in other places, if you look at the shoreline zoning ordinance, it lays it out just like you just described, Anthony.
Okay.
Yeah, as I recall, the backing for that was the MDEP recommendation in their last model ordinance.
Yeah, that's right. And again, that's getting to kind of what has been the trend, is what I've seen, is to have, if there's going to be a local appeal of a planning board decision to a zoning board, it's the trend has been to have them be appellate review type of appeals. Not in every case, again, but that has been sort of the trend that I've seen.
So what's the pleasure of the board? How would you guys like to proceed?
What do you think?
I'm in favor of leaving, actually, what would be wonderful would be to have the option to decide at the time of appeal whether it should be appellate or de novo, based on the nature of the appeal. My concern is that the nature of the appeals to planning board decisions sometimes involves questions that never came before the planning board per se. And in that respect, I feel it would disenfranchise the citizens of the town to force it to go appellate.
Yeah, and I think if you keep it as is, it in all reality, it doesn't have a huge practical effect, except for under what I'm seeing is 3 ordinances. So 3 ordinances right now are de novo because they're silent. And that's the commercial development ordinance, the floodplain ordinance, and the minimum lot size ordinance. So you would be, that's where you would leave it. If you left it as is, those are the 3 types of decisions you'd review in de novo capacity. Shoreline zoning is explicitly appellate, and the other 2 ordinances go directly to core, multifamily dwelling and subdivision. So if you're okay with that, the other way you could do it is leave it as is now, and maybe in a future amendment next year, whatever, you look at the other 2 and you review the floodplain ordinance, for example, and see if you want to keep it ordinance by ordinance, make a decision ordinance by ordinance is the other way to do it. The one thing you cannot do, and I will point this out, the court will say you have to have a standard review that is in the ordinance, that the board can't make a decision on which one to apply. It has to be explicitly laid out in the ordinance, the law court has said, so that applicants know what to expect of when it comes to them in an appeal.
So when it's silent then, and we use the default, isn't that in breach of what you just said?
No, the way I read this is it says it sets a default. So in other words, it says all appeals from the planning board decision to the zoning board are de novo unless an ordinance says otherwise. So that means if you look at like the floodplain, for example, the commercial development and the minimum lot size are silent, so they do not say otherwise. So you'd apply that default de novo review. That's the way I would interpret that if asked today. If you get an appeal from one of those 3 ordinances, I would say, because your Board of Appeals ordinance sets a de novo review as the standard, that's what you would apply. If you had an appeal from the zoning, shoreline zoning, it does say otherwise. It says appellate, so then you would apply the appellate standard.
Okay. So where would the fact finding part come into this, Phil?
So you should be making fact finding whenever you're, well, you should have a written decision every time that articulates the reasons for your decision. Fact finding itself is really only applicable when you have a de novo review, because you're making new facts. Technically, that's when you're making new facts. When you're doing an appellate review, you're actually reviewing the facts, the record that's already, that the planning board, for example, already had. So you're having conclusions of law, written decisions with conclusions of law. Some people, not to confuse it more, some people use that term interchangeably. So they'll say findings of fact. What they really mean is your written decision, right? That your written decision that articulates the reasons for how you came to your decision. It's always important to have a written decision that articulates your reasons. Some boards don't do it. They get away with it until it goes to court. And then what happens is the court sends it back almost every time. If there's not a decision that is articulated with reasons, they send it back on a remand for articulations.
And so now that after Phil advised us of that, that's why we now do findings of fact on every planning board decision. And you will recall in that Sandy Code case that Mr. Katsifikas
Right,
helped you
Right,
draft the findings of fact.
right, right,
and we did in the
right side.
right side
Mhm.
case, same thing, and we've done it in the past.
And in fact, in that case, the other case, you in fact, in your capacity of reviewing an appellate, did remand it. Remand it to the planning board for additional findings of fact because you found them insufficient, you may remember. So
Right.
that's what a court would have done if it would have gone to the court, for example. So we can keep it as is. If you do keep it as is, the one thing I would suggest to change, and I didn't write my comment, but I said it out loud, is you'll see there are no ordinances listed in section 5. So that's an error that's somehow left over. You can just delete that. So it can simply read or failure to act with the code enforcement officer or planning board in the administration of the town's ordinances. That's one way
Where
to
are you
fix that.
reading that?
I'm in the first sentence, the third and fourth line. It makes a reference that doesn't exist. So it says that suggests there's a list of ordinances in that section 5, but there are not in fact any ordinances listed. So you can just change that to just in the administration of the town's ordinances.
So I think maybe we leave things as is possibly. With that change that Phil suggested?
No, in fact,
No.
just as Phil just said, we just delete the words listed in
Right.
section 5 and put the word towns in front of ordinances, and it would stay as is. And then, if you were to hear an appeal of a shoreline permit, then that would be an appellate review because
Right.
that's what the ordinance calls for.
Right. Yep. Okay.
Elmer or Dave, or do you have any suggestions or anything to add?
Thanks, Dick. I mean, Mike, I think that Dick's suggestion to make it as easy as possible on the residents of the village are obviously where we want to go. I don't like the idea of someone having to spend an inordinate amount of money to hire an attorney and go before court. I'd like to keep it as simple as possible for the town.
Right. Well,
I'm just reading this. Basically, I agree with your decision.
Norm, are you okay with that? And Nicholas?
Yep, I'm okay with that.
I'm okay. I do think the horsepower is where it belongs at the planning board level, but I hear what everybody's saying, and I'm not that against leaving
Yeah,
it like it is.
And Norma, what we might consider doing, as Phil suggested, was, the next time, when the planning board gets done crafting a solar ordinance, maybe suggest to them if they want to look at the appeals language in the commercial development review ordinance and see if they
Right.
want to change that to an appellate review. And I think that would probably be appropriate because like Phil said, those can be pretty complex and naughty decisions.
And we can update it
Yep.
when necessary, right?
Yes, I mean, whenever we have the next election after town meeting.
Okay. So should we move on to the next?
We should.
Sure, yeah. So the next one, I just put a heading on there, which is just to tell you the reason why I'm in section B now, right below what we were just talking about. And that's because there are other types of variances, including the setback variance, which is an optional variance. You have that in D. There's another type of variance which you don't have, which is also optional, called the practical difficulty variance. I'm not suggesting you need to add that right now, but because there are two different types of variances in other places, that one that you have is called the undue hardship variance. I just put a header just so there's a terminology for it. The only other comment I really had was, for some reason, my document started having some computer problems, but I remember it if I can't get it going. Sorry about that. I'm having some sort of Anthony, could you? I'm sorry, I'm having a computer issue all of a sudden. Could you read my next comment to me, and I would refresh my
Yeah,
memory and what I wrote?
Yeah, your
Yeah.
next comment, Phil, is in section 6 under meetings. And it's for paragraph D, which says the chairperson shall call a special meeting within 10 days of receipt of a written request from any 3 members of the board whose request specifies the matter to be considered at such special meeting. And your comment was, I'm not sure this provision is needed since there is no reason to meet unless there is an application.
Yeah, that was more of a comment. Again, you can leave it, like you just decide to leave the other provision, but typically a Board of Appeals only meets when they have applications. And not at the request of a member. That's a little bit different from, for example, a Board of Selectmen or even a planning board, because planning boards have a semi policy role in the sense that they often review ordinances. I guess the one place you would think about it is kind of what we're doing tonight. That's the one area, is if you're looking at your own Board of Appeals ordinance. The other ordinances, typically are reviewed by the planning board first, but you may want to keep it in there. It was more of a comment. I hadn't seen that very often, and I couldn't think of a reason why the board would want to meet if they didn't have an application. That was the only comment. You may want to leave it.
And I, for what it's worth, I would recommend that we do, like Phil said, because we've met a few times just to review the ordinance, and this sort of
Just to
allows for
cover it,
that.
yeah.
Well, kind of tongue in cheek, I was hoping that Phil was going to suggest that the planning board and the Board of Appeals shouldn't review ordinances.
And we've met for training too before. We've met for training purposes before too. And so how
That's
would
right.
that meeting arise if somebody didn't ask for it? There's no application.
That's right. If it wasn't on your standard monthly meeting, that's right. If you want to have it in an alternate date. Okay, I think we should just leave that. There's more of a question more than anything. Under hearings, so now on page 5, section 9. I think the reason why I put this here, my comment here is so that what the provision says is the board must schedule a public hearing on all appeal applications within 45 days of the board's determination that the application is complete. But what it was missing was the meeting about completion. And so there was sort of a step missing there. And so what I suggested is you could potentially instead just change it for public hearing within 45 days of receipt of an application. And you could have a completeness review at that meeting and a public hearing at that meeting. Alternatively, you could say, shall put it on the next meeting for a completeness review and schedule a public hearing. But typically boards of appeals don't always have to do multiple meetings. You've probably seen that. You usually get an application, you you schedule it and you hear it at the same time, it's better for everybody, quite frankly, if it moves along that way. Sometimes you do have to have multiple meetings. So what I was going to suggest is you just have to schedule an appealing within 45 days. You put it on your calendar within 45 days, essentially, and you can do your completeness and your public hearing.
I'm good with that. I think that's good.
Okay.
We've had, I'm sorry,
Go ahead, Norma.
we've had a couple of incomplete applications, and
Yeah.
so if we go to all the trouble of giving notice to all the appropriate parties and assembling a hearing, and then say, well, you need a site plan, it just seems like a waste of everybody's time when we could have maybe had call a special meeting to review it for completeness or something quicker than our next scheduled meeting, but I can't see putting off the completeness question until the public
So
hearing.
do you usually, is it your standard practice to have a meeting after receiving applications solely for completeness, and then you would then schedule
Yes.
a public hearing and
That's what we've done.
review of the substance? Is that how you,
Yeah.
is that your standard practice?
Yes, sir.
Okay, so if that's your standard practice, I think all we need to do is put, we need to have a new A, if you will. This will become the B, right? So, or we could put it at the beginning of the sentence. What I could actually, maybe, so we don't have to do it on the fly, Anthony, I could suggest some language here and send it to you tomorrow.
Okay,
But
that'd
what
be
I would
great.
suggest adding here is essentially a sentence that the board will place an application on its agenda at its next business meeting, or 30 days, whatever you want to say, for a review of completeness, and then schedule a public hearing within 45 days of that determination. Then application is complete. Does that make sense?
Fine. That's fine.
Okay.
So Phil, just a follow-up question to that. So if they have the meeting to determine completeness and they find that it's incomplete, would that necessitate another meeting to determine completeness before the 45-day window?
That's what happened before.
Yeah.
In other words, it could be many months
Yeah.
after we receive one until
Yeah.
someone,
Well, at least a few weeks.
well, I mean, if they continually fail to turn in a
Right.
complete application, it could be many months before we even determine completeness, and then another 45 days in addition to that for the public hearing.
Yeah,
Okay,
I think the other option, which I think MMA has suggested, is that if you have an incomplete application, you simply deny the appeal and let the process start over.
no. And then the findings of fact would note that the reason it
The
was
finding of
denied
fact
was
would say
because it
that
was an incomplete.
The denial is
application.
because the application was incomplete.
That
What
is
do
the
you
other
think,
option.
Phil?
That is the other option. That's kind of what I was suggesting, if you just want to do it in a single meeting. It could go either way. I mean, I think from an applicant's perspective, what I usually hear is one of two things. They don't like it when it goes for a very long time, right? So it feels unduly, lengthy sometimes if they're looking for an application. On the other hand, I think they probably would like the opportunity to not have to reapply and pay the fee and all that sort of thing. One way you could go forward is with the amendment that I just recommended, is you essentially are giving them one shot. You're giving them a shot to kind of supplement their application and fix it. They come back for the public hearing. At that point, if it's still not sufficient, you could deny it on the basis of not being a sufficient application.
Mm.
So it kind of gets to both. I think that kind of solves the issue if you do
Yeah.
it that way. So you don't keep going forever, in other words, if you don't want to. Yeah.
It's worked well, yeah.
That sounds like the most efficient
Yeah.
process.
Okay.
I have a question about that, may I?
Go ahead.
I've wondered about this with, I can't remember, it was a few years ago, but is it legal or ethical or whatever for somebody on the Board of Appeals to look at the application and notify the person that they're missing a site map, just without meeting? I mean, if it's something that simple, is it legal for a member of the board, a knowledgeable member of the board, to sort of look at the application and say, there's a conspicuous missing piece here that you need to fill in. And why don't you go get that thing and bring it back to us? It seems like the process is pretty complicated for an ordinary citizen who's not.
It's a
What-
good question, Norma. So a board can only act as a body. So as an individual board member, you have no authority. But as a body, you do have authority. So I would say, no, you should not be doing that. That would be considered inappropriate for a single board member to do that. Where I have seen some towns do with, quite frankly, larger amount of staff, so there's more people to do it, is that sometimes that initial review happens by the code officer or the planning director, for example, in a town. So a town, a resident of town would work with the staff to make sure the application was complete before it was then forwarded and put on a board's agenda. So that's where I've seen that happen. But an individual board member should not be doing that because you'll be a voting member as a member of the body in the future.
Wouldn't that really kind of fall under the realm of like ex parte communication as well? I mean, you as a voting
Yeah.
member of the board should not be discussing this with an applicant.
Yeah, that's exactly one of the things. That's right. Yeah. So on the other hand, you could have, to the extent, I don't know at this point if it's appropriate with your staffing or not, but you could have that role being done by your code officer, for example. Sometimes the code officer staffs the board and that's their role, is to determine whether an application is ready to go to the zoning board, for example, with all the appropriate materials there.
I looked at this a couple of times because this issue has bothered me. We've put
Yeah.
quite a bit of time into the process. And the town does have a wonderful list of things that you must have in the application. Here's how it's a 2 or 3 page instruction sheet. If the people get that and when they get it, they're told by somebody from the town, this is all required. So your application will need these things to be complete. Well, that's a little better, I think. At least they're on notice.
Yeah, and just so you know, Norma, applicants for commercial and shoreline permits do receive that sort of instruction packet. And so it won't ever even get past the planning board unless they have all of those elements. And as you may well know, our planning board is very meticulous in its work. And so it is rare that someone submits an application and it is deemed complete the first time around at the planning board process.
Well, we just heard one that had incomplete. It was incomplete, it was getting completed as we heard it.
Which one was that?
The big house back at the end of the road on the lake.
Okay. All right.
I think that.
Okay,
I think that was,
so I'll make
also-
that tweak and send it back to Anthony.
That may have also been an issue in Brightside too.
Yeah.
I think we went, we went with a meeting with their technical advisor before the application actually went to hearing. Yeah.
Yeah.
But we've had that in the past, yeah.
So is everyone all set with
Yeah.
Mr. Socio making that change?
Yeah.
Could he
Yes.
restate the change? I'm just sorry, just restate the change.
Sure, I'll add a sentence that says to A, that says the board will after, and this is actually where I need some direction if you want to use another 30 or 45 days, but within, I was going to suggest 30 days to keep the process going. Within 30 days of receipt of an application, the application will appear on a Board of Appeals agenda for a completeness review. That's the sentence. I may play with that language, but that's the idea, that within 30 days it'll appear for a completeness review. And then the rest of it will continue. The board shall schedule a public hearing on appeal, like application 45 days of the board's determination that the application is complete. So it just adds that first step in there. Yeah.
Okay. So I really have been bothered by this. So what we need to define when it is received then someplace in our ordinance, because it's not clear. When is it received? When they hand it off to the town? When somebody from the planning board touches it? when we meet and discuss it for the first time, when is receipt?
It is received when,
Yep.
go ahead, Phil.
Sorry, Anthony, I didn't mean to cut you off. It's, if you look at the paragraph above, I would just refer to 8A, which is that a person must file an application for an appeal within 30 days at the town office to the attention of the chairperson. Upon receiving the application for appeal, the town office promptly notifies the board chairperson. So it's upon receipt in the town office. That's what I
Upon
would say.
receipt in the town, okay,
Yeah.
good.
And that has been our practice, Norma, at least since I've been town manager. Anytime that we've received an application, I immediately notify Mike. And then Mike calls the meeting.
And the clock starts ticking right there.
The clock starts.
Right.
Good.
Okay.
Page 6.
This is a very practical, is that under B, it says that the notice of a publication of a hearing has to be at least 10 days prior to the hearing. That comes from nowhere. That's just a town decision. That's not in state law. You already have a 7-day posting requirement into the subdivision ordinance. It was a way to start to, I've seen some towns start to try to standardize these because it makes it a lot easier, quite frankly, on town staff, who are the ones actually usually notifying it. If we start to have more of a standard notice, so you don't have 7 days here, 10 days there, 13 days here. It was a recommendation just to bring it to 7 because you already have that with a subdivision ordinance notification requirement.
Okay.
And
So
that-
Phil, what was that, Norma?
Okay.
And that complies with the statute?
That's
7
right. The
days?
statute doesn't have any, notice, specific notice requirement.
Okay.
It just,
just a
so
town
the
thing.
general notice under, yeah, it's a town thing. Yeah.
So we'll change it to 7.
Well, Phil, I do
Yep.
have one quick question about that.
Sure.
Is it statutorily required that we publish notice in the newspaper of record?
No, under the Freedom of Access Act, all that's required is that you give reasonable notice to members of the public. That's all that it says. So it's never been defined. Each municipality gets to define that for themselves and what reasonable notice is. There are a couple of very specific statutes that have specific notice requirements. For example, one is when you amend a zoning ordinance, or shoreline zoning ordinance, it specifically says you have to have notice 7 and 13 days prior in the newspaper. But in terms of applications or meetings, it's really left to the municipality and what reasonable notice means.
So would it be appropriate then for the town manager to recommend to the Board of Appeals that we strike the language about published once in a newspaper of general circulation in the town? For these reasons: 1, it's terribly expensive. And 2, because the readership of the newspaper is so low now and no one is reading the public notices in the newspaper. And since we have something called the internet now, we can just post those notices on our website and draw attention to it through other means rather than spending hundreds of dollars on a notice that maybe a dozen people will read.
I don't think in a few more years, we're going to have to worry about local newspapers, because I think they're going to be, a thing of the past.
Bite your tongue.
Well, I think you're right, Dave, and that's coming from a former newspaperman who got out while the getting was good. But it just sort of galls me that we spend money advertising something that no one is reading when we've got other tools for publicizing the fact that a hearing will be going on.
Yeah, you're exactly right. I mean, even obits are getting to be the point where they're ridiculous now.
I like that. I like that billboard up in front of the town. That's my end to the notices.
I mean,
Flashing light.
Yeah,
I
I mean,
love
that's one of the good mediums that we have available to us, along with the town's Facebook page and its website. And then, of course, we can always post it here at the town office on our cork board in the lobby. I just think that we shouldn't be I think it's a waste of taxpayer dollars, quite frankly.
If it's not required by statute, I think it's a good idea to strike it.
My question to that would be is how is our broadband around the whole area that we service? I mean, if people
Yeah.
doesn't have the good websites or doesn't have the internet, like, I don't know.
I don't know of any place in, I mean, I know some places in Belgrade that do not have sufficient speeds in broadband, but I don't know any of them that are a black hole.
This would not substitute in any way for written notice to abutting property owners or anything like that.
That's right.
All right.
That's right. That's right.
So Phil, if we wanted to, we could, after the word published, we could just strike once in the newspaper, general circulation in the town. So we could say to be published, let's see, making the application and to be published, the date of the publication to be, oh, no, wait, to be published. at
We
least
could
10
even,
days
well, we
prior
could
to
even
hearing.
say, post it on the website. You could say, you could say, post it on the website and in the town office. I've seen something like that before. At least 7 days prior to the hearing. And then you could go beyond that, you know, but we wouldn't need to prescribe it. But at a minimum, we could show that if anyone are challenged in the future, there wasn't enough notice. Websites certainly count today. People look at websites way more than they do anything else. So
Mhm.
It's okay.
why don't I put some language together, Anthony? I'll run it by you.
Okay,
Okay.
I'll get off my soapbox
Okay.
now.
Oh,
No, that's
fine.
good. It was a good suggestion. Good
Good
suggestion.
suggestion, actually.
We like guys trying to save us money.
Yeah.
That's right.
Dave, you okay
Okay,
with
so-
that? Keeping it? Oh,
Yeah, I'm fine with it.
Alma,
Yes, I'm fine.
Nicholas?
Yes.
Okay, moving on.
Okay, the next section in D, you'll see I deleted some language and I made some clarifications in 7. And this is around this idea of your current ordinance has this concept of giving people a sort of heightened status called interested parties, which you don't need to do that, right? So that there are no party, the party to an appeal is the person filing the appeal. So that's the applicant, if you think of it that way. The applicant is filing the appeal. Anyone else who comes to the hearing has a right to speak. Generally, there's a public hearing portion. So I would say anyone has standing, quote unquote, to participate in the public hearing. You wouldn't shut someone down, for example, just because they don't live right across the street. Usually people who come, you know, in town can come to a meeting and speak. The issue of standing comes up actually when you get to court. So, and also who has the right to bring the appeal. So those are the two areas where you see standing. Who had the right to file the application? You have to have standing for that. And who has the right to appeal a decision? And what the courts have said is to be able to have standing is you need to have particularized injury and you need to have participated in the underlying proceeding. So someone has to have shown up. So say there's someone who files a variance appeal for their property. They want a variance for something. A neighbor does not want the variance to be granted. So the neighbor shows up, speaks and makes their case on why they shouldn't grant it. You grant it. The neighbor, because they're in a direct abutter and they participated in the proceeding, has the right, will almost certainly be found to have standing to bring that appeal to Superior Court. That's the general concept. So what I was reading here is it makes it a little more complicated for you than you really need there to be. So I'm looking at paragraph 2. As it currently reads, it says the board determines whether it has jurisdiction over the appeal. That's correct. That's the first thing you should always do. And then whether the applicant has the right to appear standing before the board. That's also right. Those two issues are called threshold issues for boards. Do you have jurisdiction and does the person have standing to make the application before you? The next part then says, in which individuals attending the hearing are interested parties. They would include, but are not limited to, abutting property owners and those who might be adversely affected by the board decision, which is somewhat vague. It doesn't see, to me, it doesn't, there's no reason for you to do that. and it could, you end up being in the position of having to make a decision, which may be incorrect. And what a court in the future might say, well, I don't know why they didn't say they had standing. They, it's just not necessary is my point. What you need to do is determine if the applicant has standing, allow, public comment, and that's it, essentially. And you do have already in section 10, an opportunity to receive comments and questions from all observers and interested citizens who wish to express their views. So that's already in there. There's no benefit to sort of giving a heightened status to certain people over others, is my point. In fact, could just lead to potential problems if it was appealed. So that's where I'm suggesting kind of simplifying this and cleaning it up a bit, just taking out that one step. It also suggests the other sort of effect of giving this sort of heightened status, if you will, to interested parties, is you'll see in paragraph 6 and 7 is currently the board. It actually gives the interested parties the right to ask questions directly, which I don't think is appropriate necessarily. I think interested parties, members of the public can speak during the public section, ask questions. The board can then choose to ask them or not. That's the way it's typically gone, but you wouldn't elevate them to some, like, for example, in a courtroom, who gets to be up there and cross-examine witnesses or ask questions. That's, you should treat the public as the public, in my view.
Phil, let me ask a question.
Yep.
Should we have some kind of a provision in there that addresses the issue of public comment sessions at which the general
Mhm.
public can make comment, and evidentiary hearings where the comments made by the applicant and a comment made by the neighbors or the other interested parties actually goes on the record that can be forwarded then in case of an appeal? Should there be two different steps then?
Yeah, it's a good question. I think it's covered if you look further down in 9 and 10. So section 9 says, all parties are given the opportunity to refute or rebut statements made throughout the hearing. Rebuttal testimony is limited, no new subject matter, and then the board may receive comments and questions from all observers and interested citizens who wish to express their views.
Right.
I will tell you one, so I think I know where you're getting at. So one area where you really kind of do have two parties, if you will, is if a neighbor, an abutter, appeals the granting of a permit by the planning board or the code enforcement officer. So the neighbor appeals the building permit. The neighbor is the appellant in that case. They're the ones who brought the case, so they go first. The person who got the permit is called a necessary party, not an interested party, but they're called a necessary party. If that goes to court, they have to be named as a party, for example, because they have the most of the line. It's really not the town. It's really the person who got the permit. So in those cases, you'll see party one goes and then usually let the permit holder go and present their case. And then typically when it's a code officer, you actually have the code officer go too, as a sort of third party and sort of articulate their reasons. That's how you do it. What made me a little uncomfortable about this sort of just general interested party idea is it would elevate someone who was not an appellant. It was just someone from the audience, for example, who tried to get some status that isn't necessarily appropriate in these kind of proceedings. They should just be a member of the public. They have the right to be there. They have the right to put on the record during the public comment period why they think this should be denied, for example, or granted. And then by appearing, and then if they're a butter, that gives them the right in probable standing to take it to Superior Court if they don't like the result. That's the way that would work.
These non-interested parties from the general public can speak at a hearing, even if they did not participate in the original decision or hearing or the underlying proceeding. Or not.
Right. So you're talking about like a planning board, for example, they didn't ever go to the planning board.
Yeah.
Yeah, that's right. I think that's actually because you have a general public comment period, paragraph 10.
Okay.
I would not limit people. I think it just gets Yeah, and so it just says, all observers and interested citizens who wish to express their views. So you have a general public comment period after you hear the evidence from the applicant and the appellant.
Okay,
That's how you'd get in. Yep. Because at the end of the day, it's the court who's going to decide if someone had standing or not. If they try to bring an appeal to Superior Court, they're not going to, the court gets to determine whether someone has standing to bring something to Superior Court. And your job is to determine if someone has standing to bring the application to you, right? So
Mhm.
that's why your first thing is standing, but that's about whether the applicant has standing. The person who filed the application, did they have standing?
So Norma,
You don't
if you
need to get
remember,
into other members of the public. Yeah.
Norma, if you remember when we did the bright side that we had 80 people in here,
that's, yeah,
we went down through the chain and the protocol for which the hearing was gonna be held and who could say what, when and where, and that was all directed to the public. Do you remember
Yes.
that?
I am,
Okay.
that's what I was thinking of, actually, that
Yeah.
particular proceeding. When 40 or 50 people spoke.
Right,
Well, and I think it's, as Mike just described, I think it's important to have a process where there's a time for people who want to speak to be able to speak.
right.
But then there's a time that has to be cut off so the board can do its
That's
work.
That's right. Yeah.
And I
Well,
think
then
we, go ahead.
there is the thing about
that,
aggregating your testimony or whatever. I just saw that. There is a thing about how they can enter, one person can speak the same opinion held by a group. Where is that?
There is a provision in C on page 6 that says the board shall provide as a matter of policy for exclusion of irrelevant, immaterial, or unduly repetitious evidence.
Yeah,
So that unduly repetitious is one way where the board chair has the authority to say, for example, you have the authority to limit comments, especially if you have a lot of people. You could say comments tonight are limited to 2 minutes each, and please avoid any unduly repetitious evidence. If you have the same thing to say as your neighbor, if to the extent you're able to, please combine your testimony. I've heard chairs use as a sort of matter of procedure
yeah.
prior to
good
opening up the
language.
public comment section. Yeah.
I think you're looking for what's in D2, in which Phil had recommended some changes.
But that sentence remains.
Yeah, that's actually not what
Party.
Yeah, no, I see what you're saying. I see what you're saying
Maybe
there.
requ-
Parties may be required to consolidate or join their appearances in part or in whole if their interests or
Where is
contentions
that?
are. It's in D2.
D2.
D2, okay.
One thing
Yes.
I could do is I could move that down to the public hearing portion.
Mhm.
Members of the public are encouraged to consolidate or join their appearances in part. I could move that down there. That makes more sense there, actually, in some ways, because here we're talking about the applicant and the,
Yeah,
Why don't you do that, Phil? I think
Okay,
that's a-
okay. Okay, that takes care of the whole thing, because I think we all agree members of the public need to have the right to speak. It's just what we call them, and that's all I was trying to do here. I wasn't trying to change that right. Okay, so I need a little bit, I need to do a little bit, one more tweak here, but I think I haven't where we're going here.
But I think all those changes are really good ideas.
Yeah.
Make it simplified the most you can.
Good.
Because some of this stuff is a little bit repetitious. But I think that's fine with me.
Yeah.
Yeah,
Makes-
Okay.
you okay with that, Norma?
I am. I hope we don't have trouble because it's significantly changed. But I agree with these changes, so we need to work it out.
I can get a chance to use my command voice again.
Good.
Phil, what about having, for public hearings or public comment sessions, having kind of a template and this would goes really beyond just us, I mean, the planning board or whichever, have kind of a template for the chair to
Mhm.
read at the beginning of public comment sessions. And no matter what meeting we're in, as far whether it's appeals board, the planning commission, whatever the case may be, that lets people know at the onset that while we want to make sure everyone is heard, if we've got, like we were talking about a few minutes ago, at Brightside, we had 70 people there that wanted to talk, have one person speak for them or set a time limit and let them know at the beginning of that meeting.
I think that's a great idea, Dave. Yeah, is to have so I've seen some boards that have scripts that they start out with a script, and it doesn't have to be long, but you
No.
essentially say what we're here for, what the rules are. We'll have a public proceeding, we'll have a public comment period. At certain points, comments are limited to 2 minutes. Yes, I think that's a good idea. And we can maybe work on that separately as something, but yes, sort of, they call it rules of procedure, or sometimes it's not even as formal as that. Sometimes it's literally just a paragraph you can read at the beginning of a meeting.
Yeah, a lot of hearing officers at evidentiary hearings and public comment sessions just have.
That's right.
That's
right. Yeah. Okay. Why don't we? I was just going to move along, and the rest of these comments are that last one on the bottom. By the way, I'm missing one letter, so when I make my final edits, I'll add it. So I'm looking at 7. I took away interested parties. We all know why we did that, but I say, so right before it says the appellant, number 5, the appellant goes first. That's appropriate, right? And then it goes, the board can ask questions of the appellant. And then number 7 was interested parties. What I changed that to is the permit holder in the case of an administrative appeal filed by an interested party, or I'm going to change that terminology. It's a little confusing based on what we just said. So in the case of an administrative appeal, is then given the opportunity to present their case. So that's what I was talking about. So if a neighbor, for example, files an appeal of a permit that was granted, that's the way you typically do it. You have the appellant, the appellant go first, and then the permit holder go second, because they weren't the appeal. So I'll just fix that line. That's what I was intending to do there. It's just a small tweak. I think there's only one more real thing. Just 2 more things I'd like to talk about. So on page 7, decisions, section 8. You'll see I deleted policies specified in the comprehensive plan. I think I mistakenly cited findings of fact by the board in each case. That findings of fact, I think, means when you're looking at something, for example, in an appellate review. I think that's why you meant to keep that. That inadvertently got deleted. But I did mean to delete policies specified in the comprehensive plan. That's a complicated thing for people, and it's somewhat sensitive for some communities, but because a comprehensive plan is an important document for communities. But what the courts have explicitly said, and where boards can get in trouble, is if they try to apply standards in a comprehensive plan as part of an application. Because what the court has said, the comprehensive plan is not a regulatory document. It is a plan. It's just that, it's a plan. The documents that have regulatory teeth are your ordinances. The ordinances implement the comprehensive plan. The comprehensive plan, if you ever read it recently, the comprehensive plan has a lot of stuff in there. It's not generally specific, right? It's what you'd like to see as a community, where you'd like development to go. It uses somewhat vague terms generally, purposefully, because it's a planning document. Where we've seen this is in a planning board statute, sometimes ordinances, where they'll, in a site plan review, one of the things that will be in there is, does it comply with the comprehensive plan? Well, that's very vague. There's things you could pull from the comprehensive plan. So what the courts have said is that's too vague. And it's potentially unconstitutional. Applicants need to know exactly what standards are being applied to them. So, and in the other case, this is just not applicable here for you. It's just not applicable, right? That's not what you would do when you're a variance, for example. You don't look at the comprehensive plan, you look at those variance criteria, which are from a statute. In an appellate review, you're looking at the standards of the ordinance of the application that they applied for. building ordinance or something like that. It just doesn't belong. It's vague. I recommend deleting it for those reasons.
Should section 1C be removed concurrent with that?
Let me double.
That's because it's specific to the comprehensive plan.
You could keep that in if you want to. That just says that you should become familiar with the comprehensive plan. It doesn't say you're applying it. It's a little different. I could go either way on that one. I think it's fine to leave it in. But
Okay,
yeah. So that's all that. The final comment I had was appeals to Superior Court. This is just a thing that the courts have said is the courts don't like it when towns tell them what to do. So the court already has the authority to extend deadlines. They have that authority. They can do that. I think it's called good cause section. They don't need you to give them that authority. So I just delete it. They wouldn't look at it anyway. They would decide what they want to do anyway. So that just doesn't belong, and you should take it out.
There goes your power, Mike.
What's that?
There goes your power.
I don't care anymore.
Yeah. Yeah. For example, if you made a ruling that this cannot be extended by the court would just ignore that. Like that's not something you have the authority to tell the court.
That's sort of like being overruled on your objection and say, but I strenuously object.
The court may not overturn our decision, right? And then like that.
I was gonna say, I had no idea that the Maine court system has something in common with my teenage son. Does not
right.
like to be told what to do.
So those are all the comments that I had. There's a little bit of cleanup to do, but
Yeah,
So, once Phil sends me, as he mentioned, the cleaned up copy, I will forward that to all of you guys so that you will have it and can take a look at it. If you have comments, you're gonna have to shoot them to me quickly because we're gonna take this to the select board on Tuesday evening. So for their final approval, we already have warrant articles crafted to put these before the voters. It's just the final version needs the select board's blessing. Okay, and I don't see anything that would hinder that in this case because I think the changes that Phil has suggested are not substantive or massive in nature. They're sensical.
Yeah, they're good changes in a lot of
Yeah.
ways because this gets rid of some old vestiges and also some vestiges from using another ordinance as basis for crafting ours.
Well, I appreciate you saying that, Dick, because I've been questioned by some people about why we're having our attorney review these ordinances, because we've never done that in the past. And I think the corrections that we've made here is evidence that we do need legal reviews of our
Right.
ordinances.
Yeah,
And this whole discussion is beneficial to us as a board too, I think,
absolutely.
or to me anyway.
I'd much rather have
Thank
our
you.
attorney tell us we're wrong at this level than wait till we get to court.
Absolutely.
You're right.
So anyway,
That's the reason that we do this stuff,
All right.
you know?
Phil, we appreciate your time, sir.
Yes, sir. Thank you.
Yeah.
thank you for having me.
Thank
Yeah,
you.
okay, thanks. And I'll get that to you tomorrow, Anthony.
Thank you.
That was good.
nice job.
Yes.
Yep, nice job.
Okay, so let's see. We'll go back up to the old business approval of the August 25th, 2021 meeting minutes.
Yep.
Everyone had an opportunity to read those and check them out.
Looked fine to me.
It looked fine to me. I Do you have a copy, Val? Did you check?
Yeah,
Okay.
going through it right now. Just trying to figure out where I was. I remember I was on top of the mountain, so.
Yeah, that's right.
Yeah.
I'll move we approve the minutes as submitted.
Second.
Hey. Thank you, gentlemen.
Who seconded? Did somebody?
Nicholas.
Nick,
Nicholas. Okay, all in favor, we'll take a roll call vote. Nicholas,
Yes.
David Bornar,
yes,
Toma,
Yes,
Dick,
Yes,
Val,
Yes,
and Mike, yes. Motion's approved. What else? I guess that's about it.
next.
I don't know if we need a next meeting yet. do
We
we?
have no applications.
We have no applications. And you're gonna shoot us the revised.
I will, and I will also send everyone the, when I send out the select board packet, I'll make sure I include everyone, send you the Zoom link if you'd like to Zoom in and just be available and participate in that discussion. I don't think there'll be much of a discussion, but we'll see.
So that'll be next Tuesday night, right?
Next Tuesday night at 6:30,
February 1st.
February 1st.
That's at 6:30, right?
6:30.
so that's the select board approval, and then there's a public hearing, right?
Yes, ma'am. So at that select board meeting, Norma, the select board will set the time, date, and place for the public hearing. And Holly, if memory serves me correctly, I think it might be February 16th, but again, that'll be in the packet as well.
Thank you.
Are they gonna do the cemetery ordinance the same night?
Yes,
That's Tuesday, right?
Mhm.
Anthony,
Yes, sir.
I think the candidates form is February 16th as
Oh,
well.
you were right, Nick. So maybe it's the 15th that they're doing the public hearing. But you're correct. It is, I got it confused. The candidates forum is on the 16th.
Okay. Any other things that we need to discuss? If not, I'll entertain a motion to adjourn the meeting.
Motion to adjourn.
Okay. Seconded by Mr. Bourne. We'll adjourn the meeting. Thank you all for your participation. I think we learned a little bit, and it was a good idea to have this and get this onward and upward. Hopefully, we can do it again in a couple of years. Thank you.
All right. Good night,
Thanks, all.
everybody.
Thank you.
see you guys. Stay warm.
Yeah, you too.
Yeah.
Sure,
Jeez.
Andy.
My fireplace is going right now.
Jesus.
Mine too.